Okay, testing, you hear me?
Yes.
Good, okay, thank you.
I'm well. How are you? It is a Tuesday. Oh, yeah. They need to put it.
Arkansas lose last night?
Yeah.
They did. I saw the first inning. It was a pretty good game.
They're trying to hire success. Texas, no, there's no argument. Texas is good success. Hire them. They do it. And they're trying to short. I think they're trying to short. Not everybody can have the success that let's say now University of Catalina's having 7 build up.
We had nobodies. Our coach was nobody.
I had my parents convinced when I was. Good morning. This meeting is called to order. Mr. Troman, has anyone signed up for public comment?
Good morning, Commissioners. Les Drummond, General Counsel. We have one individual registered for public comment. We have Ms. Laurel. Ms. Laurel, if you could unmute yourself and proceed. Okay, I don't think Ms. Laurel has joined us, so we're ready to move. Thanks.
Sir. Good morning, Ms. Miller.
Good morning.
How are we today?
Very well, thank you.
Well, good. Let's tackle this.
Yes,
We have
sir.
no cases to reconsider under agenda item 3. Is that correct?
Correct, no cases.
Let's, under tax liability cases, we have no tax cases on docket 25,
Correct, no
No.
cases.
no fair housing cases.
Correct,
On wage claim cases, we have none pulled for additional discussion on docket 25.
correct. But you should have received the wage claim short form dissent list for docket 25.
I move we accept staff recommendations on the remaining wage claim cases on docket 25.
I second the motion, except for those cases of which I'm dissenting as reflected on the wage claim short form dissent list for docket 25.
Concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 25.
Motion carries with the exceptions that are noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 25. Please proceed when you're ready.
Case number 2840809, Commissioner Alvarez.
The AT decision should be modified. The claimant separated from employment because the employer implemented a new requirement that the claimant take the COVID-19 vaccine. The claimant's discharge for deciding not to comply with the employer's change to the employment agreement was not misconduct. Because the employer's new requirement was in response to the pandemic, I could support protecting the employer's account due to disaster. Modify the AT, no misconduct, no chargeback due to disaster.
The appeal tribunal decision should be modified. Since the job separation in this case was the result of COVID-19 related circumstances, the claimant should be qualified for benefits and the employer's account should remain protected from charge. As such, we should modify the AT decision, no misconduct, no chargeback, disaster.
Affirm the AT, misconduct, no chargeback.
The majority vote is pay and protect.
Short form dissent.
Thank you, sir.
Case number 2864078, Commissioner Alvarez.
The decision should be modified. The claimant quit in response to a COVID-19 vaccine requirement that was going to be implemented by his employer. Since the claimant quit due to COVID-19 vaccine requirement, he quit with good cause connected with the work. Modify the AT, no voluntary leaving, no chargeback due to disaster.
The appeal tribunal decision should be affirmed. The claimant quit his job after being told what was expected of him some 3 months in the future. Despite both employer witnesses stating that the claimant would not be fired for refusing to fulfill the expectation, the claimant resigned or quit immediately while continued work was still available. In sum, the claimant's resignation/quit was based on the possibility of termination at some point in the future and does not constitute good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2969181, Commissioner Dimerson.
We should modify the appeal tribunal decision because of the facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. The claimant should be qualified for benefits and the employer's account should be protected from charge. Modify the AT decision, no misconduct, no chargeback, disaster.
Okay, let me just confirm the case number 2696181.
That's correct.
Thank you. Commissioner Alvarez.
I would agree with Commissioner Demerson. No misconduct, no chargeback due to disaster.
Okay, thank you.
Reverse the AT, no misconduct, chargeback, and memo to investigate potential unreported earnings.
Okay, we can definitely send that memo. The majority vote is,
Short form dissent.
thank you, sir.
Case number 3003532, Commissioner Alvarez.
The decision is not supportable. The claimant quit in response to a COVID-19 vaccine requirement implemented by his employer. Since the claimant quit due to a COVID-19 vaccine requirement, he quit with good cause connected with the work. Reverse the AT, no voluntary leaving, bill reimbursing employer.
The appeal tribunal decision should be affirmed. The claimant resigned due to disagreement with the employer's policies. The employer offered the claimant the opportunity to provide a religious or medical exemption from getting the COVID-19 vaccine, but the claimant did not provide either. In addition, the claimant stated that he did not provide an exemption because to do so would have meant he would need to continue to wear a mask and do weekly COVID testing. In sum, the claimant did not want to comply with any of the employer's COVID safety protocols and quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3016095, Commissioner Alvarez.
The decision should be reversed. The claimant quit in response to a COVID-19 vaccine requirement implemented by his employer. Since the claimant due to a COVID-19 vaccine requirement, he quit with good cause connected with the work. Reverse the AT, no voluntary leaving, bill reimbursing employer, void adequate response.
The appeal tribunal decision should be modified. The employer offered the claimant the opportunity to provide a religious or a medical exemption from getting the COVID-19 vaccine, but the claimant did not provide either. Since the claimant decided to quit her job rather than file an exemption, the claimant quit without work-connected good cause. We should therefore modify the AT decision, voluntary leaving, reimbursing employer not billed, sever the adequate response issue.
Modify the AT, voluntary leaving, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 302-6478, Commissioner Dimerson.
The commission should rehear this case. The claimant was discharged for multiple issues discovered while the claimant was out of the office on COVID leave. These issues include, number one, the claimant being out at a public event during the time she told the employer she was quarantining at home. Number two, the claimant working on the payroll of several different companies while on duty for the employer and while using the employer's equipment. Number three, the claimant failing to pay past due fees to another state on behalf of the employer. The AT did not confront or question the claimant about these allegations. Because the record has not been adequately developed regarding the incidents which led to the claimant's separation, the commission should rehear this case to further question the parties about the circumstances which led to the claimant's discharge.
The AT decision is correct. The claimant tested positive for COVID and the employer sent her home. The claimant returned to the office when she tested negative, but the employer fired her after looking at Facebook posts, which seemed to show the claimant in locations other than her house during the time when she had been sent away from work. The claimant's personal conduct when she had been sent away from work, however, had nothing to do with the work, and her actions were not mismanagement of her position of employment. Therefore, she was discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 302-9460, Commissioner Alvarez.
The AT decision should be reversed. The claimant was separated after she gave birth to twins, and one of the babies fractured his skull and was admitted to NICU. The claimant quit to care for her severely injured infant and therefore had good cause connected with the work. Reverse the AT, no voluntary leaving, bill reimbursing employer.
The appeal tribunal decision should be affirmed. The job separation in this case was ultimately due to the claimant's lack of child care and a medical issue with her child. Both of these reasons are unrelated to the work, and the claimant did not submit medical documentation advising her that the medical issue with her child required her to quit her job. We should therefore affirm the AT decision, voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 303-3774, Commissioner Alvarez.
The AT decision should be modified. I agree that the claimant filed a valid claim. Regarding the separation, the claimant separated from employment because the employer implemented a new requirement that the claimant take the COVID-19 vaccine. The claimant's discharge for deciding not to comply with the employer's change to the employment agreement was not misconduct. Modify the AT, valid claim, and no misconduct.
We should modify the appeal tribunal decision. First, I agree that the claimant filed a valid claim. As to the job separation, the facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. Thus, we should modify the AT decision, valid claim, no misconduct, disaster.
Affirm the AT, valid claim, misconduct.
First, I want to clarify the basis for the majority ruling of qualifying the claimant. Commissioner Alvarez, you didn't state a specific legal reason as opposed to Commissioner Dimerson, who said disaster impact.
I would agree with Commissioner Dimerson.
Thank you. And do you wish to dissent?
Short form dissent.
Yes, sir.
Case number 303-5623, Commissioner Dimerson.
First, we should deem the employer's CA appeal timely. As to the job separation, the appeal tribunal decision should be modified. The employer stated that because of the effects of the COVID-19 pandemic, the employer ran out of work for the claimant to perform. Since the job separation resulted from the effects of the COVID-19 pandemic, the claimant should continue to be qualified for benefits and the employer's account should be protected from charge due to disaster. Accordingly, we should deem the employer's CA appeal timely and modify the AT decision. No misconduct, no chargeback, separation due to disaster.
The AT should be affirmed. I do not contest that the employer's appeal should be deemed timely. Regarding the separation, both parties agree that the claimant was laid off due to a lack of work. Therefore, he was discharged for reasons other than misconduct. Deem the employer appeal timely, affirm the AT, no misconduct, chargeback.
Timely commission appeal, modify the AT, no misconduct, no chargeback, disaster.
I would agree.
We have a unanimous decision. Thank you.
Case number 3036747, Commissioner Alvarez.
The decision should not be supportable. It's not supportable. The claimant quit after her medical accommodations were denied. The accommodation was to work from home due to the claimant's underlying medical conditions and anxiety caused by her work environment. On the second day back to the office, after the accommodations were denied, the claimant suffered a panic attack. The claimant has provided medical documentation to the commission. Since the claimant quit because of the employer's denial of a medical accommodation, which led to an incident at work, the claimant had good cause to quit. As to the claimant's separation was related to a medically verified illness, it would be appropriate to protect the employer's account. Modify the AT, no voluntary leaving, no chargeback due to MVI.
Agree. We should affirm the appeal tribunal decision. Claimant admitted that she quit in response to a reprimand. In accordance with commission precedent, her quitting was without any cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback. However, if my fellow commissioners believe that the claimant should be qualified for benefits because the separation resulted from the claimant's medically verified illness, the employer's account should remain protected from charge under a medical separation analysis. Modify the AT decision, no voluntary leaving, no chargeback, MVI.
Modify the AT, no voluntary leaving, no chargeback, MVI.
Thank you. We have a unanimous decision, unless you would prefer to stick with your first vote, Commissioner Dimmons.
Second's fine.
Thank you.
Case number 3038897, Commissioner Alvarez.
The decision is not supportable. The claimant separated from employment because the employer implemented a new requirement that the claimant take the COVID-19 vaccine. The claimant's discharge for deciding not to comply with the employer's change to employment agreement was not misconduct. Reverse the AT, no misconduct, void chargeback.
We should modify the appeal tribunal decision. First, I agree that the chargeback ruling should be voided. As to the job separation, the facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. We should modify the AT decision, no misconduct, void the chargeback ruling, disaster.
Modify the AT, no misconduct, void chargeback ruling.
Are you wishing to put that under disaster rationale, sir?
No.
Okay. Majority vote is no misconduct, void chargeback, but it's not under disaster rationale.
Let me consult real quick.
Mhm.
Mr. Chairman, a short form dissent on the section of the law, 207.044.
All right. And did you have further comments, sir?
Nope.
All right. Thank you very much.
Thank you.
Thank you.
Case number 3046056, Commissioner Alvarez.
The decision is not supportable. The claimant was discharged for failing to perform to the employer's standards. The claimant had complained of manpower issues and was doing the best he could. The employer has not provided sufficient evidence of misconduct connected with the work. Modify the AT, no misconduct, chargeback, sever validity of claim, and void adequate response.
We should modify the appeal tribunal decision. First, I agree that the validity of claim and adequate response issues may be severed. As to the job separation, the claimant failed to meet important deadlines after communicating to the employer that certain projects were on schedule. These deficiencies at an elementary school site compromise the integrity of the building and safety of the children. Because the claimant had met the employer's expectations in the past, his failures to adequately carry out his assigned duties constituted mismanagement of his position of employment. We should therefore modify the AT decision, misconduct, no chargeback, sever the validity of claim, and adequate response issues.
Modify the AT, misconduct, no chargeback, sever validity of claim, and adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 306-0035, Commissioner Dimerson.
The AT decision is not supportable. In similar cases this year, we have held that lack of proper information can be just as misleading to a party as improper information that is given to a party. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all the NMPCs that it needed to protest. That is entirely, certainly an option that is available, and it should be mentioned on the NMPC, particularly in the context of the pandemic, when the claimants, employers, and TWC were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, we have testimony from the employer that the claimant quit her last work without giving a reason, while continued work was still available. Accordingly, we should reverse the AT decision. The employer filed a timely response to the chargeback notice, protect the employer's account from chargeback.
The AT decision should be affirmed. The agency mailed the notice to the employer's correct address of record, and the notice stated the deadline to respond. The employer admitted receiving the notice timely and also admitted to then filing the response late. The employer testified that the late filing was due to their inability to timely process a high volume of UI documents, which is a circumstance completely under their control. There are no good exceptions to the timeliness rules. Affirm the AT, the employer filed a late response to the notice of maximum potential chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 306-2360, Commissioner Alvarez.
The AT decision should be modified. The claimant was discharged when he failed to receive a COVID-19 vaccine after the employer implemented a COVID-19 vaccine requirement. Since the claimant was discharged due to a COVID-19 vaccine requirement, he was discharged for reasons that were not misconduct connected with the work. Modify the AT, no misconduct, no chargeback due to disaster, void adequate response.
Agreed. We should modify the appeal tribunal decision. The facts of this case support the conclusion that the job separation resulted from the COVID-19 disaster. The claimant should be qualified for benefits and the employer's account should be protected from charge. Modify the AT decision, no misconduct, no chargeback, disaster, void the adequate response issue.
Modify the AT, misconduct, no chargeback, sever adequate response.
Do you wish to?
Short form dissent.
Yes, sir, thank you.
Case number 306-4086, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant was discharged for violating the employer's zero tolerance workplace violence policy after an altercation with a coworker. In support, the employer presented a witness who questioned the claimant during the incident investigation. The claimant admitted, in quotes, he got all mad and lost his mind in telling the coworker, if you want to fight, let's fight. These statements are considered admissions against interest and an exception to hearsay. Furthermore, the claimant testified that other employees had to push the claimant and the coworker away from each other. This indicates that the interaction quickly escalated towards the physical plane. Finally, the employer provided written statements from witnesses to the incident, which showed that the claimant's words and actions threatened violence. Thus, because the weight of the evidence established that the claimant violated the employer's workplace violence policy, the claimant was discharged for misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The appeal tribunal decision should be affirmed. The claimant denied the allegations against him under oath and the employer's witnesses did not personally observe the final incident. In accordance with well-established commission precedents, the claimant's firsthand testimony under oath should be given greater weight than the employer's secondhand hearsay. Accordingly, the employer failed to establish by a preponderance of evidence that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct charge.
Short form dissent.
Yes, sir, Commissioner Dimerson.
Case number 3066166, Commissioner Dimerson.
The appeal tribunal decision should be modified since the events that led to the job separation were the result of COVID-19 related circumstances. The claimant should continue to be qualified for benefits and the employer's account should be protected from charge due to disaster. We should therefore modify the AT decision, no voluntary leaving, no chargeback, separation due to disaster.
Ms. Miller, I would agree with Commissioner Dimerson.
Reverse the AT, misconduct, no chargeback, adequate employer response. Short form dissent.
Thank you, sir.
Case number 3110490, Commissioner Dimerson.
We should modify the appeal tribunal decision because the facts of this case support the conclusion that job separation resulted from the COVID-19 disaster. The claimant should be qualified for benefits and the employer's account should be protected from charge. Therefore, modify the AT decision, no misconduct, no chargeback, a disaster.
I would agree with Commissioner Dimerson.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response. Short form dissent.
Thank you, sir.
Case number 3146542, Commissioner Alvarez.
The decision is not supportable. The claimant was discharged for allegedly failing to fully investigate an incident. The incident in question occurred while the claimant was off duty. She gathered statements from individuals involved and filed a report. Although the employer alleges that the claimant's statements did not match the customer's account of events, it appears to match the information provided in witness statements. The employer did not present evidence to explain what they believe was inaccurate. The employer's policy merely states that the incident should be fully investigated and provided no guidance on what actions to take. The claimant had no notice that her investigation was not considered complete. Reverse AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. As a store manager, the claimant knew that she needed to investigate serious incidents at the store she managed. Regarding the final incident, the claimant based her official report on the statement of a single witness. She failed to speak to all the employees present that day about the events that led to the police being called on a customer. By not fully and thoroughly investigating the incident, the claimant mismanaged her position of employment. We should therefore affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Dimerson. And that was the last case pulled for additional discussion on docket 25. You should have received the UI short form dissent list for docket 25.
I move we accept staff recommendations on the remaining UI cases on docket 25.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 25.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 25.
Motion carries with the exceptions noted.
Thank you.
Thank you. Is there any other order of business come before the commission?
None here, Chairman.
Is there a motion to adjourn?
I move that we adjourn.
Second.
It's been moved and seconded to adjourn and we're adjourned.